Okay, good afternoon, everyone. I'm really hoping you can hear me. So, welcome to the OR Society's People Analytics SIG's very first webinar. As it's our very first webinar, there are likely to be some technical glitches, and I'm likely to forget a thing. So hopefully there are lots of people on here that can remind me. There's also a Q&A option. So you can ask us questions there or in the chat at the bottom of the screen. So if you do have any questions for our presenter anytime during that, then please just write them in and I will pass them on. Okay, so I am very shortly going to introduce David Reeves, who's going to talk to you about GDPR awareness. I really should know David's job title. I just know that he's the person I go to whenever I have a GDPR question. And so whenever people ask me GDPR questions, I'm like, I'll go and ask David. And it seemed more efficient just ask him to do this webinar. I'll be filling you in on more details about the society at the end, but for now, I'm just going to hand over to our presenter, David.
Thank you very much, Jennifer. I'm just going to, thank you for inviting me. I'm just going to fiddle around the controls. So hopefully, Jennifer, if you can just confirm that the slide's still up. Yep, good. So welcome everyone. My job title is slightly long and convoluted and I didn't actually come up with it, but it is the Information and Security Business Partner. So it's a good reason why you don't need to really bother remembering it. But basically, I've been asked to just quickly go through a bit of GDPR, but really how GDPR or what GDPR issues we need to consider when using personal data and using or processing personal data, or both synonyms in this case, can basically be doing anything with data. So in particular, we'll be focusing on the actually analytical work around personal data. So as Jennifer says, there's a chat option. So if I'm afraid you're all fixed to being muted for the webinar. So if you do have anything you want to say, either type it into the chat, or if you want to actually ask your question, just ask on the chat if you want to speak, and we can unmute you. There will be time for questions at the end, but if something occurs to you or you just want to say something, just feel free to put it in the chat. And I think with no further ado, I'll get started. So firstly, I'll just cover that quick aim of the talk. It's to really answer some of the queries that we have around using personal data at a very high level. So this is aimed mostly at either analysts or those who commission analytical work. And the aim is, hopefully, at the end of this session, you'll either know that you can work with personal data with confidence, or at least you'll know where to go to get that confidence. By which I don't mean the pub, but I mean who in your organization you'll need to contact in particular. So we'll start with a fairly easy one and then move on. You'll see that there's a link to the ICO website there. The ICO are the Information Commission's Office. They are the ones who are the regulators for GDPR in the UK. I'm sure people probably know anyway, but GDPR will continue come Brexit, or come what may with Brexit, really. So the ICO are the source of wisdom for all that sort of information. This particular slide, all the information from it comes from the ICO, but I'll just quickly run through just so we're all on the same page. Personal data is what GDPR is about, and personal data is any information about an identified or identifiable living individual. It's a bit legalese, as you might expect from GDPR, but essentially think about having a spreadsheet which has David Reeves, job title, whatever, blah, blah, blah. That's personal data because it's got an identified person, that would be me, in the name field. If it's identifiable, it would be some other characteristic that could be associated with me. So it could be my job title, for example. It could be my civil service job number. Anything like that could lead into me specifically is personal data. Yeah, so within personal data, there's a special category data, which is essentially specific, particularly sensitive personal data. So if you think of what you might think of as name card information, like name, job title, email, phone number, while that is personal data, and if that was to be unauthorizedly disclosed, then that would be a breach. It's obviously of a lot less importance to the individual than some other information, such as sexual orientation, political affiliation, trade union membership, etc., which might pose more of a risk to that individual if it was to be disclosed when it shouldn't be. Finally, information about a deceased person does not constitute personal data and is therefore not subject to GDPR. Obviously, when we're using personal data, there's some sensitivity that needs to go on around here. So usually, even if you're talking about someone who's recently deceased, or a group data set of people who are usually recently deceased, you might want to think about at least treating it a bit like personal data, just to avoid any unfortunate repercussions afterwards. So also personal data is what is anonymized data. If a data set has been aggregated and treated in such a way that no one individual can be identified from the resulting data set, then it's not personal data. But there are a few caveats on that. Probably the biggest one is that people can be inferred from apparently anonymized data. So a good example, which I've got here, is I've got the very originally named Dave's Coffee as an organization. And Dave's Coffee, they're a coffee chain with nationwide stores, no less. They hold personal data in terms of recruitment data for applicants who apply for their stores. That's all fine. Now let's imagine that they want to set up a new project just to analyze that data in some way or another. Now, possibly they think that they can use aggregated data in an anonymized form. So that this might be the case, for example, of it wouldn't have any names on it at all. It would just be an individual with various characteristics and a whole list of them. So on face of it, that seems fine. There's no way that anyone can be identified from that. But then it goes that goes down to the details of what those fields actually are. So for example, if the organization contained fields such as branch applied for, whether they were successful in the application, ethnicity, gender, and so on, that alone would probably be enough to potentially identify individuals. So let's take Dave's Coffee's Lincoln branch as an example. If they've got one branch in Lincoln, and from that data set, they can say that there's only one woman from a BAME background who was successful, who works in that store. That person is now essentially identified. They're certainly identifiable in that someone going for a data set will be able to actually say that individual here in this row is Glenda, whatever their name might be. And so anything on top of that, for example, it might be if this was collected, sexual orientation, maybe their performance views, some personal information about them would be disclosed. So in that case, this would not be anonymized data. There are ways to do that. Essentially, what we would probably do in this case would be masking the data. I will come on to that sort of thing a bit later on. Just bear in mind that anonymized data doesn't need to be treated as personal data, but you do need to be very sure that it actually is anonymized and that you can't identify or infer anyone from it, reasonably infer. That leads on to pseudonymized data. So some pseudonymized data is personal data that has basically replaced an identifiable field with some separate value. So for example, the example I used at the start, if you have a row of HR records, except you've replaced all of the personal identifiable fields with a candidate number. So you'd have candidate number, whatever, role, when they were employed, their salary, etc. That's pseudonymized data in that while no individual is shown from that record, you would be able to identify them if you had access to that separate field, in this case, the candidate IDs. So that would be pseudonymized. It is an extra level of security of the data, but it has to be treated as personal data. So that means we have to go through the process which I'm about to outline. So in an example of Dave's Coffee again, let's say they've realized that they need to use personal data. They might reasonably pseudonymize the data as a precaution, as a safeguard. So things to bear in mind here is that you would need to remove quite a bit of personal data in order to actually properly pseudonymize someone. So if you, take me as an example, if you remove my name but you get my address and maybe my date of birth, for example, it would be possible for someone to identify me quite easily from that. having to actually know what my candidate ID reference is. And the next one, last one in this particular section, is about non-pseudonymized personal data. So this is a raw data set. So this would be, using some of Dave's copy, it would be a list of everyone who's ever applied for a role there, whether they're successful or not, any diversity stats, etc., etc. There will be an occasion where you need to share this. Usually, to be honest, that will be when most of you on the call, I assume, would need to access it, would be to do that analytical work. Because it would be harder to do analytical work on pseudonymized data than non-pseudonymized data. But because it hasn't really had any treatment to the data set at all, it has to be handled with a lot more sensitivity than normal. I will deal with sort of security issues a bit later on. But those are just some of the definitions we've got there. Okay, so I'm now going to start with going through what the process is to get sign-off on using personal data. And this will hopefully provide some answers to the questions around how we, or how you as analysts would need to use this personal data, because that should be covered off as part of the sign-off process. But this is a very wordy slide, I'm afraid, but essentially what GDPR does is it places an obligation on organizations that handle personal data to clearly document what they're doing with it. And that's an exercise that needs to be repeated whenever personal data is collected for whenever personal data that's previously been collected is being used for a new purpose. So from a GDPR point of view, from a sign-off point of view, if there's no difference between someone saying, I've got this great idea for how we could collect data and use it for a project, and someone else saying, I have this data set currently available and I want to use it in a new way. Under GDPR, they will both be treated the same, i.e. you will need to complete a number of documents, which I'm going to go through now, and get their sign-off on how it should be done. Before I get to the second slide, I should say that this is the bare bones GDPR requirement. Your organization will almost certainly have some processes already in place. Key roles to consider would be the data protection officer and some form of essentially a sign-off figure, so SRO, senior responsible owner, or senior risk owner. And the key documents will be the privacy notice and a data protection impact assessment. A full list of documentation under GDPR is available on the ITO website through that link. A privacy notice will always be required whenever you're processing data. Well, there may be some examples where there would be various secret elements that I'm not going to dwell on here. I don't have any experience on myself. A DPIA, on the other hand, will be done whenever whenever the processing of data will carry a high risk to an individual. And that's quite vague what that might mean. There'll be some collection of data that clearly don't present that risk, and there'll be some that clearly do, and there'll be a large number that may or may not, and it'll be a bit of a grey area. So that will be up to your local DPO team or individual to determine that. Likely there will be procedures in place to make sure maybe there'll be a triage document that will determine whether it meets the barrier within your organization for needing a DPIA. And so you just need to see what your internal processes are on that. On the privacy notice, just a quick one. So as I said, privacy notice will always need to be done, and a privacy notice will always need to be made available to those data subjects. So there it comes to the question of who that data subjects are in terms of how widely available you make the privacy notice. So I'll take an example of civil service jobs, for example. Anyone can apply for civil service jobs. So their privacy notice is on their website on gov.uk site. It is published both on their website and on gov.uk site. So it's probably available for anyone who has access to the internet. Alternatively, if you think about the internal employment processing of personal data within an organization, that will again need a privacy notice, and within your organization there will be a privacy notice somewhere for employees, but that will not be made public, or it usually won't be made public, just because there will be no need for anyone external to the organization to actually see it. I'm then going to cover the lovely 6 legal bases for processing personal data. I'm not going to go into any huge details on this, but essentially both the privacy notice and the DPA, if one's required, will need to justify why we're processing personal data, and we need to use at least one of these 6 in order to provide that legal basis. Something quite self-explanatory. Legal obligation would be basically we're processing personal data because we're legally required to. In the case of recruitment data, for example, we are legally compelled to keep the data for, I think, 2 or 3 years. So that'll be so one of the legal basis we'd have for processing data would be legal obligation. Vital interest is usually if we need to process personal data to in the protection of someone's life or well-being. So hospitals, for example, might have a reason to keep that. Public task is a nice, I don't want to say get out as such, but it's largely get out for any public-facing organisation, whether it's civil service, public bodies, or local government, whatever. Public task is definitely a good one to use. Legitimate interest, on the other hand, is a slightly odd one. It essentially means that if there is a legitimate interest for an organisation to process personal data, and that collection of personal data doesn't conflict with the legitimate interest of the individual, then they can collect personal data. The key caveat with this one is that, unlike public task, it's specifically the case that you cannot use legitimate interest if you are a public body using data for a public task. You would use public task for that. And then finally, the last two, contract and consent. Contract is when you process personal data on behalf of a contract. So again, if you're hiring someone, that you process their personal data in order to form their contract, for example. Consent's a final one, which I'm going to deal with very briefly here and then probably not mention again. Consent under GDPR has to be clear and informed, and it has to be genuine consent. So what that means is that you'll need to know what they're giving their consent for, and they need to be explicit in giving consent. So on a slightly related topic, if you go to a website, first time you go to it, a little cookie page will appear, and it'll say, you agree to sign up to using their cookies or not, yes or no. Those companies that say opt in by default are against, well, cookie legislation, or against GDPR in this case. By default, we cannot assume consent. We have to be given consent. In addition, we have to tell people how we're using the personal data. So if we decide to change halfway through how we're using the personal data, we would need to inform them and get their consent. They can withdraw consent at any time with no repercussions. So that's another fact to bear in mind. And finally, consent has to be genuine, by which I mean there can be no idea of it being forced in any way. So a good example would be if you have a recruitment, if you hire people and then when they're hired, you ask for that, you use legal basis as the reason for collecting some other data. Often there would be the implication that because someone's just joined, their line manager, say, has asked them to fill in this consent form. It's their first day. There's quite a lot of pressure on them to say yes. And so consent might not be the best option. It might be quite contested. Last thing I was saying consent is that if you do use consent, make sure you save copies of those consent forms, whether they're electronic or done on paper. And I will not talk any more about consent. As long as I haven't bored any of you completely, there's a link below that takes you to the IC website, which goes into a lot more detail. So I'm going to go back to the example now of Dave's Coffee, just to run through how all of this ties together. So Dave's Coffee, as I said, they hire people routinely, and for this example, that they hire them directly themselves rather than using any other company. So in order to do that, when GDPR came in, they would have needed to produce a privacy notice and a data protection impact assessment to provide a basis for them processing this data. The privacy notice will need to be available to all candidates when they apply for the role. Generally, privacy notices should be available at the point of collecting data from an individual. So it'll be on the website when they apply, for example. The latter, the DPIA, will be used internally to manage the risks to personal data and go into a few other things. I'll touch on DPIAs shortly. DPIAs will not normally be shared outside of an organization. There may be reasons why it would, but in general, there's not. So the recruitment team would have produced this these documents with the help of the DPO, and then would have need to get sign off. Probably the important thing to mention here is that the DPO, the data protection officer, doesn't own any of these documents. They are crucial in providing that independent advice and for basically telling the SRO that they think that they're happy with it all, but that the documents are actually owned by the team that are processing that data. So in this case, the recruitment team. In the case of Dave's Coffee, though, we've got this DPIA and we've got a privacy notice for recruitment data. If we needed to use that data for a new purpose or to do analytical work, for example, then this whole process would need to start again, meaning that a privacy notice would either need to be created from scratch, or the edits would need to be made to the original privacy notice, and the same for the DPA. The DPA would most likely be a separate new one. And on that, I'm just going to go in a bit more details about the DPA now, just to show what it really covers off. Probably the first one, risk of data breaches. In an ideal world, we would say we put processes in place so that there won't be a data breach, but there will always be some risk of data breach, whether that be a disaffected employee, absent-minded employee, a system going down, all that sort of thing. The DPA should list the top risks, essentially. I say top risks, all the relevant risks. So that would, so for Dave's Coffee, just an example, they could say member staff accidentally, one of the analytical team accidentally or deliberately emails out this massive data to someone external to the company. That would be a breach. Or it could be maybe they're hosting the data with a third party or on AWS or something like that. Then there's always going to be the risk that something happens to that third host supplier. It's important to mention here, actually, I should be clear, that it would be a breach not just if you disclose personal data, but if you lose personal data or personal data gets altered in some way when it shouldn't do. So if, I'll use AWS as an example, this would be very unlikely to happen. If they were to somehow actually accidentally delete the data or change the data in a way that we can't recover it, then that would be a breach as well. So all of those risks would be recorded in DPA. Mitigations would be put in place. So in the case of someone in the analytical team releasing the data externally, possible mitigation action would be that all analysts are given thorough training, or analysts, maybe they get extra vetting or the like. And so in this way, you would reduce the risk of the data of breach from happening. Another thing covered by the DPA, as I just mentioned, would be location of personal data. So that would be whether you have it on premise or you have a third party hosting it, whatever. That would be covered in DPA, and any potential risks would be associated with that. In government, for example, certainly within some departments, with certain sensitive data, we would not want that data held outside of the EU. Sometimes we might want it with the US, but sometimes not even there. And so location would need to be included in DPA. And that ties on quite a bit with the security of the personal data. So if you're using a data processor who, let's say someone like AWS, fairly big, secure system, that's probably okay. If you're using a much smaller processor who maybe doesn't have as many security processes in place or hasn't used such high volumes of data before, then there might be a risk in itself of that. And so we would need to manage that by making sure that, for example, the company had the right security certification, like ISO 27001. There's no complete list I could recommend here, but if you do get to the stage of doing DPIA, your organization will almost certainly have a security team or information assurance team who would assist you with this sort of area. Next thing the DPA will cover will be who personal data is shared with. So whether that be internal in the organization or external. And this simply forces an organization to document what they're doing with personal data. On the plus side, on the point of view of the analyst, what it should mean is that it should be clear from the moment you receive this data who and how you should share this data with. If it isn't, maybe because it hasn't been a DPA, or maybe the DPA doesn't mention that, you would want to get that process in place. Even if it isn't, it's just as simple as an email just saying, this is who I'm going to share it with, this is the protection I'm going to have it with. So for example, if you're going to send out personal data, pseudonymized or not, encrypt the email or the document. Probably safe to say as well that password protecting your documents means basically nothing. So that shouldn't be only recourse for security. And finally, on the DPA is the retention period of personal data. So part of the privacy notice, as well as the DPA, would set out how long we would hold the personal data for. We cannot just hold personal data because we think it might be interesting in the future. We need to have a clear reason for it. So recruitment data, for example, we would typically hold for 2 to 3 years because there's a legal obligation, and in case of challenge for over unfair recruitment, for example. That's why we'd have a 2 to 3 year retention period, and after that point, we would then need to delete the data. Deleting the data or anonymizing the data so that again it cannot possibly be identified. But if it's anonymized data, sound like a broken record, it doesn't fall under GDPR. And as I said last I mentioned, GDPR will also set out clearly, or should set out clearly, how the data will be used. So all of this process, and it can be potentially quite long, quite lengthy, is that we get sign-off from the business, from DPO and the SRO, and then we're good to go, essentially. This does seem quite a bit of form filling, I'm aware, and it is, but the form is actually usually quite useful because it forces an organization or a team to work out what they're doing, work out and state clearly what they're doing with the data. So from the point of view of the analyst, for example, you should know what exactly you'll be doing with this, who's going to get it, how long you'll be keeping it for, what you'll be doing with it, who will be shared with, etc. And any high-level risk should have been flagged to the team. So the result of this process will be more secure processing personal data, which is what GDPR was all about. So that's all good. So for example, kind of my example of Dave's coffee. The project team for using this have completed a DPA for the new processing of personal data. They will have updated the existing first notice, and that means that they're good to go, essentially. Bear in mind that things are possible and, dare I say, likely to go wrong. So if you get a breach, for example, it's the DPA and push notice and the work there that will go into how you respond to that particular breach. Very minor breaches will happen. Another common thing to encounter would be a data subject request of some form, which could be either them asking for data or them asking for you to delete stuff. So probably that won't involve anything for analysts to do, but that's something that you will encounter. And that is end-to-end the process. We'll quickly go through a couple of other common issues that come up, and then I'll open up to any questions we have. Probably the first one, I mentioned data process before, but this can trip people up. Essentially, when this is probably during the early stages of planning a project, you should work out who actually owns the data you're using or you're planning to use. By which I don't mean the individual, but rather the actual data controller. So the data controller is the person who owns the data, which means that they are responsible for it. So if it gets disclosed in the wrong way, they're liable, essentially. And also they're the ones who set out who else can use that personal data, which is where we go into the data processors. So the data processors will process data or use data, whether that be storage or maybe it's something like a messaging system like SurveyMonkey or like. They'll be using data that doesn't belong to them because they belong to the data controller. They'll be using it under fairly strict instructions, and there should be data sharing agreement in place between the two organizations. But generally, if you've got a bit of data and you don't know who actually owns that data, you should ask, because it's always good to know. Especially it might help with the question of, should we be doing anything with the data if we're the processor? Unless we've been told by the controller to do something with it, we shouldn't be touching it really. And finally, I'll mention briefly about joint data controllers. So there will be situations where more than one organization hold personal data, and maybe they both have a relationship with it, in which case both would be data controllers, so they'd be joint data controllers. An example for this in civil service, for example, would be the civil service learning website. So that is owned and managed by a team within the Cabinet Office, but the data will also belong to the organisations. So taking an example of DFT, it's their learners, it's their staff who are using the system, and so that means that they have the rights over some of that data. And for the Cabinet Office, for people managing civil service jobs, civil service learning site, it's their site, and they're the ones who own that data from that point of view. So there you have a case where two organisations are holding data jointly, essentially. So for that, they would have a memorandum of understanding, which would basically set out the respective areas of responsibility for the two. So in the case of civil service learning, for example, it would set out mostly what the Cabinet Office will do with that data and who they'll share with, just to make that very clear and explicit. And then final security, which I briefly talked about throughout. Here I'm going to talk mostly about what I'll call low-level security, so sort of day-to-day stuff. At the top levels, I think I mentioned your organization will have either a security team or information assurance team that will likely have their own process in place, that will know what the risk of the organization is, so whether they want to have the data onshore or offshore, onshore being within the EU and offshore being anywhere else. And they'll be the ones to go to basically if you've got questions about security. From a day-to-day perspective, though, there's a few common areas to look out for, and these should mostly be dealt with within the DPA, if you have one. Firstly, is how you send personal data. Talked about encrypting files, but just really having a process in place makes that a lot easier. And bear in mind that you will have people working on at 5 or 6 o'clock on a Friday night who, if they don't have a clear process to follow, can quite easily just send someone the data in the wrong way or send the wrong person the data. So you need to think about how the best way to secure that process. I mentioned masking as well, personal data, so in terms of how presenting it. Generally, if you have a small data set, or if you have a data set, and then within that you have a fairly small number of returns for certain areas. So I'm going to go back to the example of the Dave Coffee example with the only one female BAME candidate at a Lincoln store. What we would be doing if we had that sort of data set is that we'd be masking that data. So if it's under a certain number of records, so whether it be 5 or 10, most likely your organization will know, but 5 or 10 I think is quite standard, then it'll just basically be returned as a null return. So that way you just prevent that from being disclosed. And then the final thing to make is avoid being too helpful, which sounds a bit trite, but essentially people can ask for data, and because it's quite easy to just say, oh, I'd like to see the equipment data for X period of time. But just because someone asks for it doesn't mean that you should give it to them, not least because sometimes people ask for things not really expecting you to give them a whole big data set. So it's perfectly fine to go back to people and say, what exactly do you want? I don't want to give you a thing because of GDPR, but you can share some things. So avoid being too helpful. And as I said, your organization should be clear with what exactly you'll be doing at analyst as well. So I'm aware it's been a bit of a whistle-stop tour. So questions? Do you want to speak, Jennifer? I'll mute you.
I'm unmuted. Okay, so if you do have any questions, please type them into the chat. And if not, then I'll start asking questions. Here we go. Okay, that's more. Okay. Right, so I have a couple of questions. First one. Any advice for linking data?
Yeah, so linking data. Linking data, yeah. If you're talking about technical advice or just linking advice in general. Essentially, any questions around linking of data should, again, have been covered by a DPA or by some sort of process record. But if we just go to that level and you're thinking, how do you plan to use data? The question will be, what are you doing when you link the data? So what extra information are you adding to the existing data set, and how much more of a risk does that then present to if that information was to be disclosed? And then that in turn becomes a question of where is that data currently held, how's it held, and how secure is it? So, for example, if we were to talk about, I think I mentioned special category data as opposed to business card data. So if you have a data set that contains basically just name, work emails, work phone number, work job title, that's not hugely sensitive, though it's personal data. That might be held somewhere a lot less secure than anything that has special category data. So if you were to link the two to them together, you need to escalate that up to the highest level of security, if that makes sense.
There being an existing broad privacy notice written rather than updating it very specific.
Yes, so this comes down to an organization, but I'll just repeat. So who made that question? I need to find them. Yes. So the question is, and so I'm having trouble with my the mouse on my keyboard, so I can't say who sent it. But the question is, can a broad privacy notice be written to cover all the possible uses rather than updating a very specific privacy notice? And the answer is it's definitely yes. It can be done. It's probably better to do it that way, but it all comes down to the specifics. So in general, we would want to have one big privacy notice rather than 10 smaller privacy notices. One, because it's just easier to update. Two, it's because it's easier for data subjects to actually see and potentially actually read and understand. So having it multi is definitely better. There may be some, though, where the nature of processing is so different, or maybe it affects such a small number of people, that you would want to have it in a separate privacy notice. But in general, yes, having one broad one is definitely the way to go. Tips to find what? Yes. So how to find a privacy notice? So yeah, the question will be any tip to how to find a privacy notice. Again, it depends whose privacy notice it is. If we assume it's open, it's a government one that's meant to be open to the public, all government departments should have their privacy notices, external facing privacy notices on gov.uk. So you go into gov.uk and start searching, say, Department for Transport employee privacy notice, for example, or the like, then you'll be able to go that way. As I said, it is a legal requirement to have an accessible privacy notice for those data subjects who it affects. So if it's a privacy notice for any company that you're not a member of, doing a search on the internet should find something. Most websites have it at the very bottom of their page. They have a privacy notice, which might link onto others. But yeah, you just need to have a quick look. They do have to make it visible, so they can't really get away with just having it public facing but not linked to anything. So if you can't find it at all, you actually are entitled to just write into an organization and say, could I have a copy of your privacy notice, or could you tell me directly to your privacy notice? And they should do so. If you're in an organization itself, then hopefully you've got an internet or something that you can access, and that would be able to, you should be able to find it that way.
It says, if an organization has a HR system where data is not automatically anonymized, are they in breach of GDPR?
Okay, I'm just going to repeat that. Sorry, I didn't have to sit on mute. So the question is from Bertha. It's if an organization have a HR system where data is not automatically anonymized, are they in breach of GDPR? It then goes on to say something a bit more about that, but I think the answer to that would be no. They're not automatically in breach of GDPR, but it would, again, sound like record again, but it would really depend on the actual details. But, well, firstly, I mean, we say anonymized, it would be pseudonymized, well, hopefully, because if it was properly anonymized, then the HR system basically doesn't exist anymore, because they would need to pull people out, individuals out. So in general, I'm just actually reading the full question now because it's quite amusing. Yes. I'm just pausing now just to think about that one, because that's quite a tricky one. So in general, as I said, the answer would really be no. An organization doesn't have an obligation to anonymize personal data, depending who it's shared with. That said, if it seems just the details of that particular question, if it seems that they say they're not anonymizing personal data when they're not, and then I infer from this that they can actually therefore other people can see who's applied for jobs, for example, then that does seem like they would be in breach of GDPR. So I'm not sure of any more details, but or if that's been particularly helpful, but that probably is the best answer I can give for that. Okay, I'm going to quickly skip. I'll come back to Ross's questions shortly. Yes, I see. I get that. This isn't so much a breach of GDPR, although it's definitely embarrassing. So the issue here, I think it basically comes down to name-blind recruitment processes. So essentially, if someone gets hired for a job, or no number of candidates for a job, you shouldn't be able to see what school they went to. You shouldn't be able to see their name or their ethnicity or their gender or anything like that. But at the moment, the process, at least in this case, aren't working, and so people can see that information. So that isn't a breach of GDPR, because when someone applies for a job, they will provide this information, and that is ultimately required. However, this would instead impact the name-blind recruitment process. So while this wouldn't be a breach of GDPR, this would be a failing of that particular attempt to fix unconscious bias. So hopefully that's answered the question. It's not specifically a breach, but it's also not particularly good. I'm going to skip back to Ross's question. Is data collected during a research study treated differently, exempt in some respect than typical data collection that is non-research related? Yes, it is. So thanks for the question, actually. Data that is collected for research purposes is not my area of speciality, I should say it now, but it is definitely treated differently. Namely, because it's for research, it allows certain more leeway with how you use the data. That said, everything I've just said before about masking data and being sure who it's sent with applies. So essentially, let's say we've got a university that's doing a study, and so it's collecting personal data for that study. It will have the ability, because of for research purposes, it will be able to hold that data for a lot longer and do more with it than other collections of data, but it will still need to abide by this framework. So they will still need to clearly say why they're holding that data, give a legal basis for holding that data, which research might cover some of that. It would also have to say when it does delete the data, which whatever that is, and it will need to be clear with how they protect the data when it's held. And probably the biggest thing for research data is when they do share it, making sure that people cannot be identified from it. Yes, so Ross has replied. I would say the ICO website is the best place to go for that. There's some links in the slides, and I think the slides can probably be shared a bit later on. Or we can just search ICO just ICO guidance and actually get you the right to the right page. It's quite a good website. They certainly have a specific section dealing with research, so I would say go in that direction. I think that's it for questions. Unless in that case, before you do, I will just I'm aware of sharing my screen. I'm going to share a different page now. So this I'm now sharing with you. Hopefully, am I sharing with you the upcoming events for the? Yeah. So I'll now unmute you, Jennifer, and you can talk about that. You're able to go.
Okay, so this is our Society People Analytics SIG webpage. I think I've shared the address in the SIG. If you have any questions, please get in contact with us on this and you can join up. We're hoping to send a survey round after this webinar. We're really wanting suggestions of what else you would like to be covered in a webinar, as well as obviously any feedback you'd like to give us. I think Katie did a little bit of a blurb to everyone in the chat as well, but I have now obviously lost that screen. So anyway, I want to thank David for agreeing to do our very, very first webinar, and hopefully there will be some more that will appear on the website mentioned. And if there aren't any more questions, or anyone reminding me of a thing that I was supposed to do, then I will say that this is the end. Thank you very much for joining us, and I hope you found these things useful.